Hey there, it's Michael Bovey, your debt settlement expert here at Resolve, and I'm back to talk about lawsuits again, only this time the more stressful version of this conversation. So it's more about you've been sued or you are on the eve of being sued, and that causes a whole bunch of considerations to start to need to be thought through. So let's start with the easier, softer version of you're on the eve of being sued. If you're getting a letter from an attorney that is licensed in your state, and you can tell they all send, at least one letter typically, and it's, hey, we're involved. They might even say that an attorney hasn't even looked at your file yet. But trust me, these law firms get these accounts because they're also authorized to sue you. But these letters, they look a little bit softer of a collection letter, but they're really just the shot across the bow that you have your mini Miranda that is on all these initial debt collection letters that are required to go out to us. And it says, hey, you've got 30 days to dispute or request validity of this debt. It's on all these notices, the initial letter you get from a collector, including law firms. And you're thinking, okay, it's just another one of these collection letters. It's not. It's a letter from somebody that's licensed to practice and regularly collects debt. They have an office in your state. So what it means is typically after that 30 days goes by, you can expect shortly thereafter, usually, a suit to be filed. Sometimes can take a while to serve you, but it's coming, right? So in the prior video about how to set yourself up in a debt settlement plan to avoid any risk of ever having to deal with attorneys or lawsuits, we talked about resources and timing being the two main ingredients that go into a good settlement plan. Well, it's no different if you're about to be sued or your account landed with an attorney. You still need the resources to mitigate all this, right? To engage in the process of keeping this from becoming a judgment. So it is going to accelerate the timeline. You have an opportunity to prevent them from filing any suit. All you do is just engage in the process with enough resources. There are times where you can get a settlement with an attorney. Lump sum is better. It usually can increase the savings by a certain margin. You can do settlement plans. You can do payment plans with your settlement. Let's say it's half off over a prescribed period of time. And so engaging in the process right away, if you've just gotten this letter and you're watching this video, upload it right away to your profile. Send a message while you're logged in, click the helpline, and send a message to your counselor. There's ways to get this immediately in front of us so that we can connect you with a partner in the network that works, another attorney, somebody that does debt negotiation on your behalf, can contact the attorney for the debt collector, the bank, the debt buyer, right? So getting involved as early as possible can sometimes mitigate the risk that they're actually going to file the suit, and you can actually be engaged in repayment of a settlement before that ever happens, right? So acting quickly is important even though you haven't been sued yet. So let's talk about the fact that you've been sued. All right, well, it's a pretty formal process when they file a lawsuit. Sometimes you're noticed because a licensed process server comes to the door, knocks on it, you open it, here's your package, here's your lawsuit. There's different ways that they can perfect a process of service depending on the state you live in, but most commonly it's a physical delivery. There's sometimes where you actually know you're being sued by some other attorney. And what I mean by that is that the courts are a public record, and local attorneys, mostly bankruptcy attorneys, but local attorneys will fish through the public records and grab people that have been recently had a suit filed against them. You may not even know about it yet, and use your address that's in the public record to mail you a solicitation. Hey, we can help. You've been sued. Contact us. And they want to help you file bankruptcy, which frankly isn't all that bad of an idea. You do want to talk to a local bankruptcy attorney with experience when you have too much debt, and especially if it's reached the level of having been sued. See if Chapter 7 anyway is an option for you. If Chapter 13 is the only option, settlement is really a good alternative to that in a lot of cases. But then again, Chapter 13 will knock any collection action and set it aside while you develop your plan and then implement on that plan in that version of bankruptcy. Chapter 7, nip it in the bud right away. So there's reasons to talk to attorneys. But let's assume for a moment that settlement is your goal. That's what you want to do, and you've been sued. When they file a lawsuit, it starts a very formal process. Once you're served the documents, you have a period of time to file an answer to prevent them from filing a motion for summary judgment, or default judgment. Summary judgment is if your answer sucks. So in other words, it doesn't create any controversy. It's like, hey, so you told the court, Your Honor, they told the court that that they're broke. And that's why they shouldn't be sued. But nope, that's not going to fly because they're just going to file out. They admitted the debt, motion for summary judgment, and the judges grant these pretty much bang, bang, bang all day long. And the default judgments for sure because you didn't respond, right? So that's important. You're on the clock once you've been served. And a lot of states, it's around 4 weeks. Some, it's not quite 4 weeks. This is a great opportunity to do some things. So if you've been sued, you need to upload a copy of the summons and the complaint, right? So usually there's like a 1-page, 2-page thing that is outline of the summons, some identity stuff, and the fact that you're being sued in what court. And then there's usually the complaint, the lawsuit that's attached to that. You need to upload all those documents into your user profile on Resolve so those can go to your partner, our partner at the Resolve Network, to attorney partner, so that they can start negotiation with the law firm that's suing you on behalf of a creditor or a debt buyer. In this time frame, before an answer is due, a lot of times a negotiation can happen. Again, back to resources and timing. If you have the right amount of resources to deploy, get a settlement, sometimes it's lump sum, and other times you can do it over monthly payments. Not a great deal of time, like some creditors before any lawsuit action is filed. Usually you have a really condensed period of time that you can do and fund your settlements with, but payments are possible. And so they engage in that process, your attorney negotiators, and they get a deal, and you start performing on it. Be prepared to have to sign a consent or a stipulation to judgment that says if you, okay, you're agreeing that you're going to pay this amount every month by the 25th of every month, let's say, for 6 months, and if you fail, you're agreeing to this debt, you're waiving all defenses, and we're just going to file this with the court, and we're going to have an actionable judgment if you fail to follow through. So be aware, that's very common. It's very rare to have not to have to sign that. You do the lump sum settlement, that doesn't come into play because you're not agreeing to payments over time. So when you do this, when your negotiator's doing this, you're committing to something you can follow through on, okay? And you're putting yourself in a position to use, usually for most of us, all of your resources and money is going to that specific, that's on fire. When you're being sued, it's on fire. And so you want to put that fire out before you look at anything else in your periphery. You might have other debts, right? And so you have to engage in this process, ignore some other things, and then come back to those later. Sometimes when you're in a situation where it can create a domino effect, it's like, okay, this guy sued me. That's when I went out and did my research, and I'm taking this seriously. I don't want to do bankruptcy, and I've got a settlement going. But while I'm paying on that one, this other guy comes along that I haven't paid in around the same period of time, and now they're knocking on my door, sometimes with the same attorney. And so you have this domino effect, and it's, again, resources and timing that are going to line up to help you prevent that, be proactive, not just sit on your laurels and deal with this one and only wait for the next one to sue you, because I've worked plenty of files in my 20-plus career where that is what they have to do because resources are that thin. If you have it to do differently, be that person, and I understand if you can't, but try to be that person that is proactively looking beyond this fire and trying to put out any that have any potential of starting as well. Okay, so we've covered what to do if you're hearing from an attorney who hasn't sued yet. And we've talked about uploading all of your documents and getting involved immediately with your negotiator, your attorney negotiator here through the Resolve Network, and dealing with any active lawsuit that's been filed. And then let's talk about what happens if it's too late. You've been sued. They've got a judgment against you. Look, if you're not with a judgment in most states, there are a few states like Pennsylvania, North Carolina, South Carolina, Texas, and Florida, where wage garnishment is going to be next to impossible for these guys. So what they have are bank levies that they can do, or file a lien against your property. These things, when they have those liens, okay, it's negotiable to the same degree as if, in most cases, they're just sitting back waiting for you to have to refinance that property or sell it, and then they're going to get all their money, plus interest if the court granted it. Okay, what if you're being garnished? It's really hard to negotiate if you're being garnished because they figure they're just going to get all their money as long as you have that job. And it's true, unless you meet certain exemptions. So if you're being garnished, you have an opportunity to show the court that you meet those exemptions in your state by petitioning the court. Call your court clerk, and they'll tell you how to do it. And show up and show how what you make, your income for your family size and everything, and all your expenses. It's creating a hardship to the point that you can't cover the basics. And if you qualify, you can actually get all of the garnishment removed or at least lowered. that's super helpful, right? If you can get the garnishment eliminated, they become more negotiable. Now, if they've got a bank levy out, let's say you're in Texas, and a lot of bank levies happen because while your wages are protected, nothing in your bank is protected unless you're on a fixed income from exempt sources like Social Security, disability, things like that. But if you're a wage earner, they can take money out of your bank account while you're sleeping, basically, right? You wake up and the $500 is gone. If they've just gotten a bank levy, they're pretty unnegotiable. They've got a live one, right? They're like, this is a hot ticket, right? They're not really focused on taking any kind of discount. But if you're just sitting here and you're dealing with a judgment, and it's however long it's been, nobody's really even trying to collect on it, and that actually happens more frequently than you would think, you can go and negotiate these things. The savings aren't great. Okay, existing judgments, you go and negotiate. For most cases across the board, dealing with the attorney that hasn't sued you yet, dealing with an active lawsuit that you're going to, try and negotiate before you have to file an answer. You're dealing with settlements that range usually, in my experience, between 50 and 80%. Judgments are no different. Sometimes it's even higher than 80%, right? If they've got a lien on property that they can see from Zillow or whatever app, and within plus or minus 10, 15% of accuracy, they can see that you have all that equity, why would they take less, right? They're going to get paid eventually. So these settlements aren't great, but they do happen. I do want to point out that there's another element of being sued that I missed. It's that you file an answer. So the attorneys in the Resolve network, if you're being sued and you still have time to file an answer, they can call and negotiate, but what if you don't have the resources? Remember the matching up the resources and the timing. What if you need a few months before you have enough for a lump sum, right? You're just waiting on your tax refund. You're waiting on a bonus. You've got a family member that's going to loan you what you're missing in order to settle for a lump sum, that larger amount, and you just need to buy yourself a month or 3. Well, the attorneys in the network actually do that. They charge. They have a fee, but it's pretty nominal, and it's affordable enough where it will make sense for most people being sued over, anything like $3,000, $4,000 or higher, where you pay that and then they charge their 15% of savings fee like all the negotiators in our network. So you file the answer, it buys you time. And that's sometimes in some states, cases progress very rapidly. Sometimes it's only a couple of months' time. And then there's other states like California whose courts are massively clogged with this stuff. It can buy you many, many months to come up with the resources to do a lump sum settlement or agree to a term deal. So those are the things that you want to be aware of when you're being sued. It is something to avoid, absolutely. But for many of us, it's part of our settlement path. There's nothing we can do about it. And even if you're watching this video, you're only 3 months late on accounts. You've got a 36-month plan with creditors that are known to be kind of aggressive or sell-to-debt buyers that are going to be aggressive. And you want to know in advance, you're watching this video of like, hey man, what am I up against if I'm sued? Look, I've been helping people settle litigation files for the entire time I've been doing this kind of work full-time since '98. It's very common. It's more common than you believe to settle out of court at any stage of the collection process, even with judgments. It's just that it usually costs more and it freaks people out. It's you're not used to it. Somebody knocked on the door. Sometimes it's a sheriff, right? And they serve you these papers and it's completely unsettling, but you can absolutely navigate this. There is help. We can help build plans around this event and helping you prevent any more of these events from happening. And sometimes, guess what, guys, ladies, it's a crap show. It is actually, you're in a situation where you found us, you were unemployed for 2 years, 18 months, whatever it is, and you're just now starting to be able to put together a plan to see your way clear of debts, and you don't want to or can't do bankruptcy Chapter 7 for some reason, then we're going to work with you. We're going to help you. We're going to find a way through and build a path through all of the muck and get you safe to the other side. It's just you're going to get a little dirty, because if you don't have resources that align with the timing and the needs of preventing from having to get in the muck, it's where you're going to be for a little bit until you get to the other side. I'll see you on the next video.